We are live, ma'am.
Okay. Hello, everybody. Thank you so much for joining us. We are at the fourth session of the Network Dialogues by the Craft and Law Center at JSBF. So today, we have Benjamin Wong with us, who's also been my data protection teacher at NUS when I was doing my master's. So thank you so much, Benjamin, for joining us. So Benjamin is from NUS also. He's done his LLB from there, and he's done his master's from London School of Economics, and he's also Sheridan Fellow at NUS. So that's how he joined as faculty. And his main research interests are in data protection laws, etc. And also he also teaches a little bit of contract law as well. So we are very excited. We'll be discussing his paper today. Which is on controller-based responsibility in the EU and why that's a problem. So thank you so much, Benjamin, for joining us today. So tell me, Benjamin, how did you think of this paper? I mean, what were you looking through that you thought that you would write something like this?
Thanks, Ashawari. I'm happy to be here. I'm grateful for the invitation to give this network dialogue today. I think the idea behind this paper arose from three data protection cases that were decided by the CJEU, or the Court of Justice of the European Union, right? And if you look at the paper, you will see that I focus very much on these three cases. So these are the cases of Fashion ID, Wirtschafts Academy, and Jehovan Tudistajat. And after I read these three cases and what the CJEU was doing with the concept of controllership, I felt compelled to write this paper, because it seemed to me that the rules that they were creating and developing were clearly problematic, especially if you look at it from the lens of non-European data protection law, right, which takes a different approach. And once I got started on these three cases, that got me thinking about the other problems, right, that arose from the concept of controllership inside EU data protection law, right? So all this work led to the paper. Yeah. Sorry, Ashawari, I think you're muted.
I'm so sorry. Yeah. So you mentioned about a controller-based system. So as you know that India does not have any laws, right? It does not have a specific privacy law yet. We are still we still have a bill which hasn't been passed. Although privacy is a fundamental right in our country. It's recently been declared as a fundamental right, but then we still don't have a law yet. So what would you recommend for a country which doesn't have a privacy law yet? I mean, for which system would you think we should adopt when we are drafting laws?
Yeah, thanks for the question. Well, in my personal opinion, which is of course open to debate, I'm happy to take questions afterwards. My opinion is that a controller-based system in the EU style is generally a bad idea and should not be followed. Actually, I prepared a few slides, so if you don't mind, I could share the slides with everyone.
Just a minute. Yeah, I'll just ask the IT person. Vishnuji, can you just give Benjamin the sharing rights?
Actually, I think I do have sharing rights.
Okay. Then you can just share your screen. No issues. Yeah.
All right. Can I check that you can see the screen? My slides?
Yes, we can. Yes, we can. Shoini and Kirti, can you see too?
Yeah, I can see.
Cool. Thank you so much. Yeah.
Great. So I thought that I kind of anticipated that this question would come up. And so I prepared a few slides to sort of take us through the thought process. This paper really focuses on the idea of responsibility, right, in data protection law. So we know that in data protection law, we have a range of duties, a range of obligations, right? So you have the obligation to get consent, to secure personal data, to provide access, to erase personal data, and to provide transparency, right? And so the key question is, who do you impose these obligations on? And intuitively, I think most people would say that you impose these duties on whoever is processing the personal data, right? If you collect personal data, then your duty is to get consent. But here we see that Europe has taken a rather different approach, which is to ascribe responsibility to what is known as the controller, right? So in the paper, you will see that I set out two different models, right, of responsibility. There's the European controller-based model, and then there's the Commonwealth non-controller-based or processor-based model. So maybe I can talk a little bit about what I mean by the controller-based model. If you look at the GDPR, right, Article 4.7, you will see the meaning of controller. This is the body which, alone or jointly with others, determines the purposes and means of the processing of personal data. Right, so that's what controller means. And the GDPR also says that the controller is responsible for complying with the principles of data protection. Right, so the duties in data protection law in the EU are all put on the controller. Right, so now we need to answer the question, who exactly is the controller, right? What does it mean to say that you determine the purposes and means of processing? And for these, you look at the three cases below. I'm not going to go through all three. I'm not going to go through the cases in detail, but essentially the three cases adopt a very broad concept of controllership. So if you look at the case of Virchow's Academy first, you will see that the court has said that it is enough if you take part or you participate in determining the purposes and means. So you see that this is already a broad reading of Article 4.7, right? Just participating is enough. And further on, in the next case of Jehovan Todistajat, the CJEU says that as long as you exert influence, right, over the processing of personal data, then you are taken as having participated, and so you are a controller, right? So this is what I call the influence rule, right? As long as you have influence, you are responsible, right? And of course, the last case in Fashion ID confirms this position. So this controller-based model that has been developed by the CJEU is a very broad one. And I would argue that there are a few problems that come up with this model. And the first thing is that this may lead to responsibility being attributed in an unexpected way, right? So there may be entities or there may be persons who are unknowingly made controllers because somehow they have some influence over the processing of personal data, right? Even though they are not the ones who are actually doing it, right? And so unexpected attribution is problematic because if you don't know that you are responsible, then you don't know, then you won't be able to comply. The second problem is that this broad responsibility model tends to group controllers into what are known as joint controllerships, right? And this can be quite unpredictable, right? And this is especially problematic because in the GDPR, there is an obligation for joint controllers to make an arrangement amongst themselves. But how do you make an arrangement if you don't know who is part of the group, right? And if the group is too big, it's also difficult to come to an arrangement, right? The third problem that I identified is that this may lead to unreasonable outcomes when you ascribe responsibility to a person who only has a little bit of influence over the processing, right? And this is unreasonable because if you look in the GDPR, there's this full responsibility rule, where as long as you are a controller, even if you play a minor role, the data subject can come to you for full compensation, right? And this, I think, seems to be a bit unfair. And the last problem is that there is a sense in the EU, I think there's a sense in the EU that when you broaden the concept of controllership, you give better protection to individuals. You make more people responsible, and so individuals are better protected. But actually, this might be counterproductive, right? Because this makes data protection law more complex, and you spread out, right, the responsibility amongst more people, right? I think this might actually lead to weaker protection. I will not talk about the Commonwealth model just yet. I'll just go to the case of India, right? So before I proceed, I should emphasize that I'm not an expert on Indian data protection law, right? So I might be entirely wrong about this. So if you look at the Indian Personal Data Protection Bill, India seems to have adopted the idea of a data fiduciary, right? And this, if you look at the definition of data fiduciary, it seems to be very similar to the definition of data controller, right? I put a text here, clause 313. So it at first glance, it looks like India has just followed Europe, right? But I would also point you to the bill clause 10, which says that the data fiduciary shall be responsible for complying with the provisions of the Act in respect of processing undertaken by it or on its behalf. Right? And so this actually makes it more like the more like a processor-based model, right? Where you're only responsible if you do your processing yourself, or if you subcontract it to someone else, right? You are not responsible for complying just because you are a data fiduciary, right? And then, so my sense is that the Indian approach is more like the Commonwealth approach, right? Even if I'm wrong, and India does in fact follow Europe, I think that it should not use the influence rule that the CJEU has chosen to develop, and instead, there should be a stricter standard. For example, in the paper, I argue for a decisive influence standard, right? So it's not just influence, but you have to have some sort of determinative power, right, over the processing. Yeah, so I hope that answers the question that you asked me.
Okay.
Let me unshare the screen.
Yeah. So the next question that I have for you is that could you explain the RPC doctrine for India as well? How do you think that features in a country like us?
Well, sure. The short answer to this is that I don't think the RPC doctrine applies in India just yet, because the RPC doctrine is really something that the court created, right? It doesn't appear in the legislation. So let me explain what this RPC doctrine is for the benefit of those who may not have read the paper. The RPC doctrine stands for responsibilities, powers, and capabilities, right? And the idea behind this doctrine is that you can get out of your data protection obligations by pointing to your personal responsibilities, powers, and capabilities, right? Which sounds strange. This doctrine first came up in the Google Spain case, right? Which you may recognize as the right to be forgotten case. And in that case, the court said, right, that data controllers have to ensure that they comply with the requirements of the Data Protection Directive, but they went on to say within the framework of their responsibilities, powers, and capabilities, right? So they added that last line there. And what this suggests is that sometimes when things fall outside of your RPC, then you don't actually need to fully comply, right? And when you look at the later case of GC, right, very recent, the court actually applied this doctrine in favor of Google, right? And here, because in EU data protection law, they prohibit the processing of sensitive personal data, right? The court said that this prohibition did not apply to search engine operators like Google, right? Because of their special responsibilities, powers, and capabilities, right? So for these search engine operators, the prohibition somehow only applies after someone asks for their personal data to be deleted and not before, which is a rather distorted reading of the provision, right? Usually when someone says you are prohibited from doing something, you are just not supposed to do it from the start, right? But because of this RPC doctrine, the court modified the rule on sensitive personal data for Google, right? So essentially, this is an excuse to get out of your data protection obligations. Yeah.
Okay.
Yeah. Sorry.
No, so you wouldn't recommend it, like it wouldn't be okay for India to, I mean, have
Mm,
that. I mean, even if there's a method of like looking at different precedents of different countries and
mm,
trying to draft, like the bill is already there, but I'm saying like if you want to make any modifications, you
mm.
don't think that our RPC doctrine should be taken into consideration for a good model.
Yeah, I don't think that it would be a good idea for the Indian courts to follow this RPC doctrine. And the reason is that if there is a problem with data protection law, right? If data protection law is unreasonable and curbs someone else's rights, fundamental rights or human rights in a particular way, then the correct solution, I think, is to conduct a proportionality assessment, right? And this is a proportionality assessment that is also conducted in Europe. And that's what I argue in the paper that the European Court should have done instead of adopting this RPC doctrine. Yeah, and
Okay.
this is especially suitable for India as well, right? Because India does have a right to privacy, and so you can balance out these fundamental rights. Mm.
So after, like in the paper, you mentioned about the three main issues that a controller-based approach does have.
Mm.
So there's a distribution issue, etc. There are three key problems that you have mentioned. So do you think that Singapore has been able to overcome all these three problems through its PDPA? I mean, the act that we all follow. I mean, in Singapore, the Data Protection Act.
Mm. Yeah. That's a good question. And so let me maybe very briefly explain what these problems are, and then I'll explain how Singapore has overcome them. The complexity problem is basically the problem that the concept of controllership is a complex one, right? It's complex to apply, so much so that the courts and the regulators have to come up with guidelines on what it means for you to be a controller, right? And this just makes compliance more difficult and more expensive, right? You want data protection law to be strong, but you also want it to be easy to comply with, right? And this concept of controllership doesn't solve the problem. The distribution problem is that once you have a big group of joint controllers, you need some way to distribute responsibility amongst them, right? And this is not always straightforward, right? There's no guidelines as to how they should do it. The third problem is the misallocation or the impossibility problem. And this is the problem that arises because data protection law ascribes responsibility to the wrong entities, right? As I mentioned, once you are a controller in the EU, the whole bundle of duties are ascribed to you, but sometimes some controllers cannot actually comply, right? So for example, if I'm a controller who has influence over the processing, but I don't actually touch the data, right? How can I make sure that the data is deleted upon request? How can I make sure that I can give access to the data if I myself don't have access, right? So that's the misallocation problem. How has Singapore overcome these problems? Well, actually, I would say that's not just Singapore, right? But the other Commonwealth sister countries as well, like Australia, New Zealand, Canada. And the way these countries have overcome this problem is through adopting what I would call a non-controller-based responsibility system or a processor-based responsibility system. And essentially what this means is that you only allocate responsibility to an entity who is actually processing the personal data, right? So if you are disclosing someone's personal data, then you have certain specific obligations, right? You must give notification, you must get consent, and so on, right? If you store personal data, then there are other obligations that apply to you, like you must give access, you must rectify the personal data, you must delete it once it is no longer necessary, right? But the point here is that the point here is that it is not the entire bundle of data protection duties that are allocated to us to you just because you are a controller, right? So it's a more specific targeted approach. Yeah, and so this avoids the three problems that I mentioned, because you don't have to distribute anymore, right? Any entity just needs to think, what am I doing with personal data? And once they know that, and of course they would know that, they will know what their duties are. So don't have to allocate. Then you also, there's no misallocation problem, because as I said, this is a targeted approach, right? If you store data, you must provide access. But if you don't store data, then you don't have to. Right? And finally, the complexity problem is rendered irrelevant because there is no concept of control. You don't have to think about who is a controller. Yeah. So that in a nutshell is how these problems are overcome by Singapore and other countries.
Okay. So, okay, all right. Now the next question is a little bit, which I think is common for everybody. So, so when we talk about data privacy, even in our class, we always have these debates on individual privacy versus the state, right? So in certain cases, the state might come to you and ask you for your personal data. Say for example, in India, we have the census, where it's a huge graph of everybody. I mean, that includes the whole population. So you would have people coming into your private spaces and asking you about your name, how many, like the members of the household, the income, and all of that, which is personal data to you, which is required for, say, maybe a if, like, to see what the country is at the moment. I mean, the economic position. So there you can't really say no, that I won't give you my data, because the reasoning is such that it's required. So what is your approach, or how do you look at this debate of individual privacy versus state requirements, or even, say, balancing? You mentioned about balancing fundamental rights as a solution for the RPC problem in your paper. So what do you feel about it? I mean, what is your opinion as a data privacy professor as well?
That's a good question. And well, as a data privacy person, I actually think that fundamental rights are important, right? But they're actually less important than what the actual operative laws are, right? So I think this sounds like heresy, but I think that actually it is more important to see what the data protection laws and other specific privacy laws say, right? Because that's what people actually use on the ground. It is not to say that a fundamental right to privacy is a bad thing, right? So I think the case of Puttaswamy is a real achievement, right, in the Indian legal order, right? Recognizing that a right to privacy exists for every individual, right? But I think we cannot stop there. And what is urgently needed are data protection laws like the Indian Personal Data Protection Bill, right? Because this is what gives individuals actual, like, specific rights that they can rely on, right? And within these legislation is where you find the balancing takes place, right? The legislature considers the various conflicting demands between privacy, state needs, freedom of expression, and so on. And the balancing happens, hopefully, properly at that level. Well, as far as balancing fundamental rights are concerned, I think doing it at the court level, right, bringing a case to court and letting the court balance fundamental rights, there are some criticisms to this approach, right? And to me, the main criticism is that it's very subjective. There's no such thing as balancing, right? There's no physical scale that you can hold, and there are no physical things that you're trying to balance. What you're trying to reconcile are abstract concepts, right? So what judges are really doing here is that they are relying on their own subjective intuitions as to what is the right outcome. And then they, I would say, dress up that intuition under the guise of balancing or proportionality in legal language, right? And this kind of reasoning tends, I think, to lead to unpredictable outcomes, because it is difficult to predict how a particular judge will react in a particular case if you have this sort of vague balancing approach. But of course, you also cannot have an absolute right to privacy, because And so some sort of balancing is inevitable in cases where the legislation does not deal with the situation, right? Yeah, so I mean, I don't think there's any end to the debate on where you draw the line between individual privacy and the state's need for information. And I think every country has its own unique way of, it has its own unique balance, I would say. So I can't really give a straightforward answer.
So how do you think that how do you think Singapore answers this sometimes? I mean, you have the bill, you have the act, so you would of course go by that. But then, what do you think Singaporean law would say about this? Like, how do they approach it? This kind of a debate, I mean.
I think the Singaporean approach in general is to say that, well, it's all relative, I think, right? So if you look at Singapore on the broad, on a spectrum of countries, I would say that Singapore tends to lean towards prioritizing the state's need for information. And the simple thing I can point to is that if you look at the Singapore's PDPA, the Personal Data Protection Act, you will know that it only governs the private sector, right? It does not regulate government use of data at all, right? And so, yeah, so I guess I suppose this is an indication of the sort of balance that Singapore has chosen to adopt.
Okay, all right. So since we are from different countries, I just wanted you to explain, what are the differences you see in terms of the regime, the data protection regime that's there in Singapore versus here. And also, would you recommend anything? And we don't have a bill, so we are in the process of it. So what do you like? What would be your recommendations? Being a data privacy professor at NUS in a country that has a privacy law, to say India, which doesn't have one yet. So what would your top recommendations be as a professor to maybe the government or something as to what all to adopt, basically?
That's a hard question. I think, I think the immediate difference that I would point to between Singapore and India is that India has recognized a constitutional right to privacy, but Singapore has not. I think so far, the Singapore courts have declined to read in a right to privacy into our constitution. Right? So India does have a constitutional basis for its data protection law. Ultimately, this may not be a significant difference because I think it all depends on how much the Indian constitutional right to privacy influences the application of the data protection law. Right, so I'm not entirely familiar with Indian constitutional law in this respect. Right. To me, I think looking at the bill, the Indian bill, it seems fairly comprehensive, and I think this is because India has the advantage of being a newcomer here, right? So it can learn from the experience of a large number of jurisdictions. If there is actually one thing that I would, but if there's one thing on my wish list as to how the Indian bill would follow Singapore, this is in relation to the personal and domestic purposes exception. Right. You can see this exception in clause 36, right, of the Indian bill. Right. So if you look at that clause, it says that natural persons are exempted when processing personal data for personal or domestic purposes. Right. So this is a common exception that you can see in other countries. But I wish that the clause has stopped there. Right. But the clause continues to say this exception does not apply when there's disclosure of personal data to the public. So I think this is just trying to catch individuals who, say, post other people's personal data on Facebook, for example. And I think here the Indian bill might go a little bit too far and actually might unduly stifle individual freedom of expression, right? My own view is that if you're an individual acting in a personal or domestic capacity, you just should not be regulated by data protection law, right? And this is the Singapore approach, right? And this is even if the individual is typing something on his social media page, right? For individuals, we already have the law of defamation to deal with cases where someone slanders another person, right? We already have harassment law to deal with cases where individuals abuse other persons on social media, right? So I don't think we really need to bring the entire weight of data protection law down on just some person who is posting something on social media. Yeah. That being said, I think the Indian bill does have a number of things that the Singapore Act does not. And so on the reverse side, one thing I like about the Indian bill is its express recognition of the concept of sensitive personal data. Right. So if you look at clause 15, you will see that the central government is obliged to identify certain categories, right, of sensitive personal data, and it says and it lays out some of the factors that have to be taken into account. So I think this is actually a clever approach to take, right, because it provides some guidance as to what data counts as sensitive, but at the same time, it doesn't create a sort of closed list, right, of personal data like the GDPR, right? And so once you create a closed list, you cannot change it anymore, right? With this approach, with what the Indian bill does, it's a bit more flexible, so it can adapt to, I guess, new types of sensitive personal data as time goes on. Yeah, so that's one thing that I think the Indian bill, as far as I know, it is quite unique in this respect.
Yeah, so I'll just open the floor to Professor Kirti and Choini if they have any questions. Yes, Professor Kirti, please go ahead.
Hi.
Hello.
Good evening, Professor Wong. Thank you for so patiently addressing our questions and talking about this topic. I apologize if my questions are very basic or simple. The framework that you suggested, or you're suggesting that the controller kind of framework might not work for India. Would I be correct in understanding that you say the onus has to be on the users of this data, like say Amazon or an insurance company who I'm signing up for? If they're taking my personal data, the onus of protecting that data is on these companies. Would I be correct in understanding it that way?
Yes, I think that's a correct. I think that would be a correct understanding of adopting a non-controller based approach, right? The non-controller based approach means that you target, right, only those entities that are actually processing the personal data. So so if you look at, for example, the EU case in Virtshaw's Academy, what happened there is that not just Facebook was made responsible, but also the person who made the Facebook page, right? And this seems like an overreach, right? So I think, yes, I would say that this approach, the approach that the processor-based approach, right, would attribute responsibility to entities like Amazon and Facebook exclusively. Yeah.
So, given what you said, Ki, the responsibility lies with me, who is sharing my data, as well as with Amazon or Prudential, which are the insurance company or the company which I'm sharing the data with. The responsibility lies with both of us. How do we go about? I mean, I'm seeing it primarily from a public perspective, people's perspective. In a country like India, where a lot of people are just coming online in the last 2 to 3 years, thanks to Reliance Jio, how do we increase awareness among the people? Or is there a challenge to increase awareness among the people that you should not give out your data willy-nilly? You should be asking so when I install an app and the app immediately asks me for 10, 12 permissions, I my antenna kind of go up. Key, why does this app need so many permissions? I try to identify which are the essential ones, and even those, if they are not needed for the task I have for the app, I choose to uninstall the app and use an alternative method. So how do we train people to ask these questions? I mean, because the responsibility lies both on the individual and the company. The company can get away by asking all the data points, saying that, okay, I need all this data for me to provide the service. And the consumer, because they don't know, might give the data.
Right. Thanks for the question. Actually, there are two things that I think there are two approaches that can be adopted simultaneously for countries that are, I suppose, are just coming in, right, to the field, where you have a society that may perhaps be less sensitive, right, to the problems of excessive data collection and processing. I think the first approach is the legalistic approach. And this approach is to adopt a more consumer protection stance in the data protection law. And what I mean by this is that in order to protect individuals who may not have the wherewithal or the experience or the personal knowledge to protect themselves, then you have to rely less on mechanisms like consent and transparency, because these are meaningless if people have no power, right, to think to exercise their discretion, right, in deciding whether to say yes and whether to say no. And instead I suppose you have to be a bit more restrictive as to what companies can do, right? So even if you get consent, you still can't do certain things with personal data, right? You have to draw certain red lines where even consent will not save you. Yeah. So that's I suppose the legalistic approach. The second thing, and this is something I think the Singapore Personal Data Protection Commission has done especially well in, is public engagement, right? So I think it is quite important in the first place to as soon as possible institute or create a data protection regulator with the responsibility of educating the public, right, about data protection and how to protect themselves, right? And if you look at the Singapore Personal Data Protection Commission, they have a fair bit of, you will see some of their advertisements from time to time, right? And they'll put out, they have public engagement sessions, and they put out guidelines that are targeted not at businesses, but at individuals, right? Telling them these are your rights, right? Yeah, so I guess that's that is the second approach from the perspective of public engagement. Yeah.
Thank you, Professor Wang. I have one more question, if I may ask. Professor Shohini, is that okay?
Sure. Go ahead, please.
This was based on one of the regulatory requirements which RBI had, I think, last year introduced, of data localization especially for financial companies in India. And one of the reasons ostensibly was data security. Does that make, to me as a layperson, it didn't make sense, because I think it would lead to a fragmentation of the internet as we see it, as we know it. And it doesn't matter if the servers are located in India or if they're located overseas, that, as long as they're online. So how would you, or what suggest, how do we address these concerns of regulators which might be misplaced?
Yeah, I think that's a good question as well. And I actually wrote a different paper, I think earlier, about data localization in the ASEAN context. So I'm happy to send you the paper if you're interested in it.
Absolutely, please. Thank you.
Yeah, no problem. But I think to answer the question, I think I agree with you in that it is perhaps I think faith in data localization may be perhaps misplaced when it comes to ensuring security, because there is no guarantee that your data is more secure just because it is in one place rather than another, right? And it may be that actually putting the data outside of the country in a place that with an institution that specializes, right, has experience in data security might actually be more secure than forcing companies or financial institutions to localize, to store data within the country itself. How to address the concerns that regulators have? Well, I think one approach that could be taken, right, and this, I think efforts have been made here, but I think generally progress has been not as fast as it could, has not been as fast as it could have been, is having a sort of international standards when it comes to data security, sort of the kinds of certification marks, right, that entities can sign up for if they prove that they have adequate data security expertise and data security proficiency, right? And with these internationally recognized certifications, then maybe countries and governments can be more secure in allowing data to be held by an entity that is outside of the country, right? Because they can trust in those certifications. But I think there's been a lot of effort to create trust marks of this nature. But I think an international trust mark, I think there's still more work to be done here. Yeah.
Thank you, Professor Wong. I don't have any more questions.
Thank you. Sorry, oh, yes.
Yeah, Professor Wong, if you would like to go ahead, yeah.
Yeah, thank you so much, Benjamin. Your paper is absolutely fantastic from so many, I mean, it's groundbreaking in so many ways. So I just wanted to tease a couple of the ideas out with you. So one is this degree of the particularized attribution that you talk about, right? Which means that when I quote, you say that there are different sets of data protection obligations that should be imposed depending on the type of processing operation in question. So I was wondering, when you're looking at data processing and what level of responsibility to attribute, you necessarily have to know what kind of organization or business entity that is. I mean, for the sake of this argument, I'm calling them intermediaries, and this question is linked to intermediary liabilities as well, because we have been debating across the world, but particularly in India, on how to attribute responsibility. And of course, the flip side of this is, the intermediary liability question. And so is this linked to that? So do you also think that if you have this kind of a system, then it's also easier to figure out the intermediary liability question?
Sorry, if I could clarify the question, when you're talking about intermediary liability, are you referring to intermediaries that actually process the personal data on behalf of someone else, or?
It could be both, right? So the intermediaries, again, they are not across the world. They have been defined very broadly. But in the data protection, I'm just taking your sort of theory from this paper, saying that, okay, let's figure out what is the level of involvement of a data processing entity. Are they doing it themselves? Are they giving it on to someone else? If they're doing it themselves, if they hold the data, then XYZ amount of responsibility should be attributed to them. Do you think we can also link this with an intermediary liability, saying that, okay, if you have, 100% responsibility, then you won't be exempt from liability, and so on and so forth? Can you take this approach and also apply it to an intermediary liability framework?
Yeah, thanks for the question. I think the approach that is generally taken inside the Commonwealth countries, and I think I should focus on Singapore, is that if you are an organization, right, that subcontracts some of your data processing to an intermediary, right, the position that has been taken in Singapore is that it is the organization that is responsible. So even if the intermediary, for example, processes personal data without proper data security, right? The organization, as it is, I guess you can loosely call it vicariously liable. Yeah, and so this prevents, the goal here is to prevent organizations from shirking their data protection responsibilities by just shunting it, right, to some intermediary somewhere. But I think it's on the broader question of whether this processor-based responsibility model can catch data intermediaries like I suppose Facebook and Amazon and so on. I think there is no reason why it would not be able to. There's no reason to believe that it would not be able to govern these intermediaries as well. Okay. I actually think the difference the difference between the controller-based model and the processor-based model is not really that whether the intermediaries are caught, because it is quite clear that in both cases, intermediaries that process personal data will be caught under controller-based or processor-based. I think the broader question is, are the peripheral or the peripheral data processors, the peripheral players, right? Are they caught as well? Yeah.
Okay, I have just one more question. Sorry, Ashavi. I want to understand the consent framework. I think you briefly referred to it, but this is really interesting in the context of India because the amount of data that is taken from people is mostly at this point of time, barring big tech, is by the state, and a large number of our population is the vulnerable, financially and tech sort of illiterate at this point of time. So if we had to take this non-controller-based responsibility system in India, do you think we need to move away from the consent system and then move towards as you call it, a more rights-based system? And how do you think that will play into your attribution theory?
Yeah, I think this is a separate but related problem, and so this is the problem of the consent model, right? And the consent model is that once the organization provides notice and gets consent from the individual, they can do whatever they want, right? And I think we both agree that there are some serious problems with this model. And I think the way to resolve the problem, especially in countries with a population inexperienced with data protection considerations, is to have what I would call purposive red lines. So, and you see this in Singapore as well. So in Singapore, we have what is known as the purpose limitation obligation, right? Under this obligation, organizations are not allowed to process personal data, to collect, use, or disclose personal data, except for reasonable purposes, right? And so even if you get consent and you give notification, your purpose has to be reasonable, right? And you can sort of extend this approach as well. And you see this happening in Canada, right? Where you don't just say reasonable purposes, but you also set out what purposes are not reasonable, right? And so you express, whether it is the court or the regulator or inside the bill itself, you specify the purposes for which you are simply not allowed to process personal data. So, for example, insurance discrimination. For example, employee surveillance, right? So this is a way by which you can limit, right, the sort of you can limit the freedom of companies to process personal data, right? And you make sure that companies with a strong bargaining position will not be able to just bully consumers into giving consent, because even if they get consent, they are still blocked by the law.
Okay. I don't know how much time we have, Asha. Do you have other questions?
No, I don't have any other. I think we have like 5 minutes left. Yeah.
Okay. Okay. Do you mind if I quickly take one more question if I have?
Absolutely. Please
Okay.
go ahead. Please go ahead. No problem.
Thanks so much. Benjamin, I have one last question, which is on the sphere of influence. You know, this problem that you try and identify in your paper. That it's a vague concept, right? But I was wondering that we do use this doctrine in some manner in other fields of law. So, for instance, we use it in competition law to some extent. We don't call it exactly that, but there is some. We also use it in banking or in big tech conversations. You know, how big are you? Your bigness, you know, your or too big to fail concept. So, I was wondering, how do you sort of look at this if this doctrine is in use very heavily in other streams of law? Can we completely discount it in the conversations around data protection?
Yeah. So actually, I'm glad that you pointed out the competition law perspective, because I think when you look at actually the phrase decisive influence, I think derives mainly from European competition law, right? Decisive influence is what makes you part of an undertaking, right? In European competition law. And so I think that we should not discount, we don't have to reject entirely, right, the concept of influence, but we do need to specify what is the standard of influence, right? It cannot be that even a de minimis level of influence will allow you to, or will make you caught under the data protection regime. And so my argument in the paper is that the standard of influence should be at the decisive influence level. And here, maybe lessons can be drawn from competition law, right? A neighboring field, just to determine when a controller has decisive influence and when it does not. Yeah, so I think I agree with you there. Yeah.
Thanks so much, Benjamin. This was absolutely
Yeah, Benjamin, I just have one question. I just came up with it. So you spoke about data localization regarding, so you said that it's not okay to always have all your eggs in the same basket, right? In the sense that you should also be keeping data with data centers which are experienced in security. But then Singapore doesn't allow that, right? There's a part in the GDPR which mentions about the fact that you cannot take out data outside of the country. I mean, there's a territorial clause mentioned. So what do you think about that? I mean,
well, I think in Singapore does have what we can call data localization, but this is really more of a transfer limitation, right? And the law says that you cannot transfer personal data outside of Singapore unless you ensure that data receives an equivalent level of protection, right? And so there are different ways of proving that the data will receive an equivalent level of protection. For example, you can prove that the recipient country has, well, equal or stronger level of protection. You can do it by contract, right? You can impose contractual obligations on the recipient. In this case, this will be the data storage company, right? So I guess there's a loose form, there's a weak form of data localization in Singapore, but it's not a real I don't think it's really a serious barrier to companies outsourcing their data security, because as long as you have a contract, as long as you have a proper contract in place, you should be able to transfer the personal data out of Singapore. The strong type of data localization is the type of rule that it does not even allow you to do this. It's the type of rule that says that you have to store the data in the country, right? Yeah.
Okay. I don't think anybody has any other questions. So thank you so much, Benjamin, for joining us. This was really, really nice. The paper is exceptional, And we hope to get the other paper you were talking about, the one that you're going to send it across. So thank you so much, Professor Shoini and Professor Kirti, for joining us today, and everybody else who's watching. Thank you so much. Have a good day. Benjamin, thank you so much again for joining us. We hope to host you again soon.
Thanks a lot. I enjoy myself as well. Yeah.
Yes.
Thank you very much, Professor Wong.
Thank you. I'll send over the paper to Ashawari. Yep.
Yes,
Thank
I'll
you.
distribute it. Thank you.
Thanks very
so
much.
Yeah.
Bye, everyone.
Bye-bye. Bye-bye.